We begin with the Supreme Court declaring the federal Indigenous child welfare law constitutional. This comes after the Quebec government opposed and appealed the law. Bill C-92 gives Indigenous peoples the jurisdiction over child and family services, and Indigenous leaders are calling it a historic day.
This ruling reiterates the message that we have been emphasizing for years, that First Nations, Inuit, and Métis are best placed to ensure the wellness of our own populations.
We have the capacity as Indigenous governments to have a full authority over everything that pertains to our reality.
Patty Hajdu is the Minister of Indigenous Services, and she joins me now. Minister, welcome back to the show.
Great to be with you, David.
Obviously, you're quite pleased with this decision. What do you think this means for your reconciliation agenda as a government in relationship with the communities affected by this?
Well, I mean, I was just actually doing some press with President Obed and President Karen, respectively, of the ITK and Métis Nation. And both of them expressed, first of all, a true appreciation of the ruling. But they also said, and they quoted a part of the ruling that specifically talked about how this is legislative reconciliation. Probably a new term for us, but I think an important one, because what I think both partners said was that they felt that the court affirmed what they've always known, that they do have inherent right over children and families in their communities, and that right has many times been extinguished or attempted to be extinguished, but the affirmation by the Supreme Court that First Nations, Inuit, and Métis people have the right to the care and control of their own children and families is a huge relief.
An important issue, an important judgment, but it's an issue, Minister, where progress has been a little bit slow, right? Since it came into effect in January 2020, only 7 Indigenous governing bodies have actually signed a deal to gain their control over child and family services. Why has that been at this pace? What do you need to do to speed it up?
Well, I think this ruling will actually help communities that have been reluctant to come forward, watching the appeals of provinces and in particular, the province of Quebec, worrying that the constitutionality of the federal law would be jeopardized. These are enormous, huge lifts for communities. It usually takes about 18 to 24 months to develop their own custom code of care, sometimes using law that existed way before contact or elements of that law. There's also the fairly substantial work of standing up an organization or an agency that's going to do that work in the First Nations and all the HR implications. And finally, there's a coordination of the funding that needs to be in place for the success to be truly ascertained. And so now I think we'll start to see more communities come forward. We have a number that are nearly concluded, and I'm thinking this will certainly accelerate that work as well.
Now that this is done and settled by the Supreme Court, and you can start moving at implementing it at scale, how do you suspect that this will change the lives of Indigenous children who need intervention but don't want to be taken from their community and culture?
You know, I've had the opportunity, David, to be at some of the signings of the coordination agreements that are in place, and they're truly some of the most moving ceremonies and events that I've ever had the privilege to attend. There is a lot of grieving and a lot of celebrating simultaneously. People are grieving for the generations of children that have been disrupted from their language, their culture, their family, in many cases that have been lost to the child welfare system. And in many cases, I mean, this is a life or death situation for children, and it's also just as painful for families. Some of us who are parents can only imagine the trauma of losing contact with your children, sometimes forever, losing children to child welfare systems that have done, in many cases, a worse job protecting your child. And so this is going to, I think, change the trajectory for children and families in this country in ways that we can imagine and in ways that we can't. And, that's what the communities talk about at the coordination agreements. They talk about the grief of what's happened through a colonial system that used family disruption as a way to undermine and indeed weaken Indigenous communities. But they also talk about the hope and the aspirations of stronger outcomes for children who are connected to their communities and their extended families.
The Quebec government challenged this all the way to the Supreme Court, not because it disagreed with the objectives of looking after these kids better, but because it argued it would infringe on provincial jurisdiction and essentially recognize Indigenous peoples as a third order of government. Now, the court said the law doesn't do that, But what are your thoughts on whether or not Indigenous peoples should be recognized as a third order of government?
Well, listen, there are a number of self-government agreements across this country. Indeed, some First Nations have very sophisticated self-governing law and agreements that they've drawn on and that they utilize and work very closely with provinces and territories that understand how valuable it is to have independent First Nations, independent communities that can make decisions, that can enforce their own bylaws, that can determine for themselves their futures. I think that this decision today really sets us up nicely on that path of reconciliation in a number of spaces where First Nations people want more autonomy, Indigenous people want more autonomy, like healthcare. And this government has been working with Indigenous partners to conceptualize what self-determination and the provision of healthcare might look like. I think that we have a new path forward with this ruling.
Autonomy is one thing. The resources and the capacity to exercise that autonomy is another. So what is the federal government prepared to do on this point to help other Indigenous governing bodies implement this kind of a child system?
Whenever a community or a First Nation, Métis, Inuit community wants to trigger these rights under C-92, it begins a conversation with the federal government, and often the federal government does provide appropriate levels of funding for the technical work that has to happen if a community is financially strapped. We understand that communities often don't have the financial resources for additional legal work, for the kinds of coordination that needs to go into place to get a community ready to resume their inherent rights. And so that work begins the minute that someone notifies Indigenous Services Canada of their interest, and then it becomes a conversation about how we set communities up for success. So each coordinated agreement also includes a fiscal commitment that's usually 10 years in length, so that communities have the runway to be able to plan appropriately, to be able to hire appropriately, and to have that fiscal comfort, that financial comfort that they're going to have the financial resources in place to do so. And by the way, we work with provinces and territories on this. The provinces and territories are right. They do have a jurisdictional responsibility to provide child and family services, and the money that they spend in that space is augmented by, for example, federal social transfers. And so we work very closely with provinces and territories so that they can come to the table with financial resources. This is a win-win, by the way, whether it's a child in Manitoba, Alberta, Ontario, Quebec. When we have kids that are connected to language, culture, and their families, actually kids do way better, and that means more functional adults who are reaching their full potential and a less of a burden on the many social services that are required for people that are traumatized.
Patty Hajdu, Minister of Indigenous Services, thank you so much for joining us today.
Thank you very much, David.
The Assembly of First Nations co-drafted the act, and they represent more than 600 First Nation communities in Canada. AFN National Chief Cindy Woodhouse-Nepenak joins me now. National Chief, welcome back to the show.
Thank you.
Child welfare was one of your top priorities when you took on this job. So how do you feel about this court decision today?
Well, I feel like it's a progressive step forward. I'm thankful to the Supreme Court for recognizing that First Nations, first of all, we never gave up our rights to begin with, but that it's recognized and that it's endorsed, that that we can't be trampled on by little governments, I'll say, by the provinces, and that we don't have to wait for a willing provincial partner to exercise our inherent rights.
The decision recognizes that First Nations have the right to self-government and jurisdiction over children in particular. Why is that so important?
Oh, it's absolutely important. It's it's always been about our children, right? From residential schools to day schools to the 60s scoop. Now we have this broken child welfare system, and that's because First Nations didn't have the rights to our children. We've always had colonial rule on us, and I think this gives back jurisdiction back to First Nations people, and we welcome all levels of government in this country to come back and speak to First Nations. In fact, we call for a First Minister's meeting and ask the Prime Minister to bring it, bring us all together in a good way to start talking about, that it's a new, it's a new day today. And, I think that First Nations are feeling optimistic for the future in that. We have a lot of work to do together, but we need to work with all levels of government as well. We know that. They are our treaty partners. I'm here in BC. I see progress of For instance, Premier Eby and the Lands Act here, progress with Wab Canoe and our First Nations Premier in Manitoba. Of course, we see the Conservative yesterday announcing policies on economic pieces, and of course there's just so much work to do. So it's time for the feds to keep it going with the federal budget in March. I know that they've done a lot of work already, and I just think bringing us all together, of course, making sure that we're not left out of the federal budget next month, but making sure that perhaps we have a First Ministers meeting and we bring everybody together to talk about how we work together in a respectful and good way.
So on this particular case, the Quebec government opposed this law, and they argued they did that because it infringes on provincial jurisdiction and recognizes Indigenous peoples as a third order of government. Now, the Supreme Court didn't agree with that, said the law did not in fact create this. But I wonder, do you believe Indigenous people should be recognized as a third order of government going forward?
I think that we should be recognized as the first order of government. And I think that we've been here long before Canada existed as a country. We've been here as good treaty partners, as good relationship partners. We're always trying, our people are always at the front lines trying to work to make this relationship work. And we call the provinces and the federal government to work with us in a good way. We also call on all Canadians, and we thank, the allies that we have in this country, right across this country. And, we're optimistic that we can find a new way forward in this country.
So you talked about not being left out of the budget. You talked about maybe having a First Ministers meeting to focus specifically on your issues that you've raised and are raised by this case. What do you need to see from the federal government on this specifically to implement the outcome of this decision on the ground in communities and for the children who may need care?
Oh, absolutely. I think, number one, respecting First Nations laws. I think there's over 90 First Nations that have been working, 90 plus First Nations that are working on their own laws when it comes to their children and care, and recognizing their laws and respecting these people, going to the table with them in a good way to find the path forward, to make sure that they're not left out of things, and to make sure that the federal government doesn't get over its fiduciary responsibility as well, to make sure that investments are made to First Nations people. And there's just so much work to do. And I think today's a good day to start.
Just as a final point, if the federal government can recognize self-government rights in law without amending the Constitution, which is where we are with this today, what doors do you see this opening for First Nations?
Oh, there's so many opportunities. And I just have to say, First Nations are ready to get to work. They're ready to, we have the tools and the solutions and the opportunities and, the discussion points. Let's get back to the table. First Nations are waiting. They've been waiting for a long time to have these discussions. And I think that it's time that we have that in this country. And I know that conversations are not always going to be easy, but they're necessary. Not talking produces nothing. And so we just look forward to speaking to Canada and, of course, to the provinces and the territories. And our First Nations have been waiting a long time. And I think that, we've governed ourselves for thousands of years before Canada was a country. And I think that we have a lot to offer.
AFN National Chief Cindy Woodhouse-Nepenak, thank you so much for your time today.
Thank you.